Basic Appraisal Principles, page 350, Unit 4, Real Estate Contracts and Financing. Methods of foreclosure. Upon default, a mortgage may be foreclosed through two methods. Some states allow mortgages to include a power of sale clause. This clause gives the lender the power to conduct a foreclosure and sell the mortgaged property without taking the matter to court. The power of sale method of foreclosure is sometimes referred to as foreclosure by advertisement. The other method of foreclosure is called judicial foreclosure. If a mortgage does not contain a power of sale clause, it must be foreclosed judicially. Even if there is a power of sale clause in the mortgage, the lender may still choose judicial foreclosure. Foreclosure by advertisement. When foreclosed under a power of sale clause, the mortgage property is advertised and then sold to the highest bidder at a public auction held by the sheriff, often called a sheriff's sale. The property must be advertised by publishing a notice in a newspaper in the county where the property is located for a specified period, determined by the governing judicial, usually 6 weeks prior to the sale. Before the sale, a copy of the notice must be served on the person in possession of the property. Usually this is done 4 weeks prior to the sale, but the lead time is determined by the governing judicial. The notice of sale generally states all of the following: name of the mortgagor and the mortgagee. And if the mortgagee has been assigned, the assignee. Original principal amount, the date of the mortgage and its recording date or registration date for Torrens property, amount owing on the mortgage and any taxes paid by the lender, legal description of the mortgage property, time and place the sheriff's sale will be held, redemption period allowed by law. Reinstatement or redemption. After the default and up until the time of the sale, the borrower may stop the foreclosure and reinstate the loan by curing the default. That is, by paying all past due installments and penalties. This is sometimes called the borrower's equity of redemption, and the period before the foreclosure sale is sometimes called the equitable redemption period. Some, not all, states have statutory law that gives the borrower the right to redeem the property even after the auction. This is called statutory redemption. To redeem the property at this point, the borrower usually pays the price that was bid at the foreclosure sale plus interest. If the state participates, it will have its own schedule for a statutory redemption period. The following is an example of a statutory redemption period. The statutory redemption period ordinarily lasts for 6 months after the sale. The period is extended to 12 months if the mortgage was more than 1/3 paid off, the property is more than 40 acres, or the property is more than 10 acres and is in agricultural use. Page 351. The statutory redemption period may be reduced to only 5 weeks if the property has been abandoned. There must be evidence of abandonment, such as boarded up or broken windows or doors, an accumulation of trash, or other sanitation or safety problems, termination of gas, electric, or water service, or 2 or more police reports of trespassing or vandalism. This 5-week redemption rule for abandoned property applies only to residential property of 10 acres or less, with no more than 4 dwelling units. The foreclosure sale purchaser is not entitled to possession of the property until the end of the statutory redemption period. The borrower is generally entitled to remain in possession until the redemption period expires. In some cases, a receiver may be appointed to manage the property during the statutory redemption period. At the sheriff's sale, the purchaser receives a document called a sheriff's certificate of sale, which should be recorded. If the property is not redeemed by the end of the statutory redemption period, the recorded certificate becomes a sheriff's deed, and the purchaser has both title to and possession of the property. The redemption period makes a foreclosure sale unappealing to many investors who, understandably, do not want to wait so long to gain title to the property. For this reason, bidders at mortgage foreclosure sales are uncommon, and very often the lender acquires title to the property by bidding the amount owed. Deficiency judgment. In some cases, the proceeds of a foreclosure sale do not cover the full amount owing on the loan. Then the lender may want to seek a personal judgment against the debtor for the deficiency. A deficiency judgment is not allowed after foreclosure by advertisement if the applicable redemption period is either 6 months or 5 weeks. In that situation,
as a veteran, you know team.
in that situation, The lender's recovery is limited to the proceeds of the sale. The lender cannot bring any further action against the borrower. In that situation, the lender's recovery is limited to the proceeds of the sale. The lender cannot bring any further action against the borrower, even if the sale proceeds do not cover the amount owing on the loan. The lender is only entitled to a deficiency judgment after foreclosure by advertisement in cases where the 12-month redemption period applies. The mortgage was more than 1/3 paid off. The property is more than 40 acres, etc. Otherwise, to obtain a deficiency judgment, the lender must foreclose judicially. Surplus. Occasionally, a property is sold at a foreclosure sale for more than enough to pay off the loan, other liens, and all costs connected with the foreclosure. Any surplus left over belongs to the borrower who defaulted on the mortgage. Judicial foreclosure. If a mortgage does not contain a power of sale clause, the mortgage must be foreclosed judicially. Also, in certain cases, a lender must foreclose judicially in order to obtain a deficiency judgment. For judicial foreclosure, the lender files a lawsuit against the borrower in the county where the collateral property is located. The lender's attorney normally records a lis pendens, LISPENDENS, lis pendens, which means a notice of pending legal action, which will make the judgment of the court binding on all persons who acquire liens against or other interests in the property while the foreclosure action is pending. Extra note, it's pointing something about taxable, and it's pointing to foreclosure sale in regards to surplus.